बिस्मिल्लाहिर्रहमानिर्रहीम। इंफॉर्मेशन बुक यूट्यूब चैनल में खुश आमदीद। द लैंड एक्विजिशन एक्ट 1894, इसके हमारे पास 8 पार्ट है और पार्ट 1 के अंदर पार्लियामेंट्री सेक्शन 1 से लेकर सेक्शन नंबर 3 तक इंक्लूड है, और पार्ट 2 के अंदर एक्विजिशन सेक्शन 4 से लेकर सेक्शन 17 तक इंक्लूड है, और पार्ट 3 रेफरेंस टू कोर्ट एंड प्रोसीजर देयर ऑन, इसके अंदर सेक्शन 18 से लेकर सेक्शन 28 तक इंक्लूड है, और पार्ट 4 के अंदर अपॉइंटमेंट ऑफ कंपनसेशन सेक्शन 29 से लेकर 30 तक। पार्ट 4 के अंदर पेमेंट, और इसके अंदर इंक्लूड है सेक्शन 31 से लेकर 34 तक। पार्ट 6 के अंदर टेम्परेरी ऑक्यूपेशन ऑफ लैंड सेक्शन 35 से लेकर सेक्शन 37 इंक्लूड है। पार्ट 7 के अंदर एक्विजिशन ऑफ लैंड फॉर कंपनीज सेक्शन 38 और सेक्शन 38 से लेकर सेक्शन 44 तक इंक्लूड है। पार्ट 8 के अंदर मिसलेनियस सेक्शन 45 से लेकर सेक्शन 55 तक इंक्लूड है। The Land Acquisition Act 1894 was in force on 1st March 1894. It shall extend it to whole of Pakistan. Section 3 deals with definition. Land include benefits to arise out land and things attached to the earth are permanently fastened to anything attached to earth. Part 2 deal with acquisition. Section 4 deal with the publication of preliminary notification and power of officers. Section 4 subsection 1 state that if it appears to the collector that any land is likely to be needed for a public purpose or company, he should publish notification in official gazette or cause a public notice. Section 4 subsection 2 state that any officer on the authorization of collector can carry out the survey of that land or locality. No person is allowed to enter into any building or any enclosed court or garden attached to a dwelling house without consent of the owner. A written notice should be published 7 days prior to interest to the landowner. Section 4 subsection 3 state that the officer authorized should pay the owner for the damage caused during survey. Section 5 deal with the notification that particular land is needed for a public purpose or for a company. Section 54 deal with hearing of objection. Section 5A subsection 1 state that any person interested may object within 30 days after notification. Section 5A subsection 2 state that objection shall be made to the collector in written. Decision of executive district officer will be final. Collector will listen to the fact and submit the cause before executive district officer EDO with the record of his findings. Section 6 deal with the declaration that land is required for a public purpose. If executive district officer EDO revenue is specified that any land is needed for public purpose or for a company, or declaration shall be made under signature of EDO or any other officer authorized. Section 6 subsection 1 describe this. No declaration can be made if the compensation is to be paid. Section 6 subsection 2 state that the declaration shall be published in the official gazette. Section 7 deal with after declaration collector to take order for acquisition. Section 8 deal with land to be marked out mayor and planned. Section 9 deal with notice to person interest. Interested person shall not meet the collector in early date and then 15 days after the date of publication of notice. Section 9 subsection 4 state that if a person interested reside elsewhere and have no agent, the notice shall be sent to him via post in letter addressed to him at his last known address, residence address or place of business. Section 10 deal with this section or section 9 shall be deemed to be legally bound to do so within the meaning of section 175 and 176 of Pakistan Penal Code. Section 11 deal with inquiry and award by collector. Section 12 deal with award of collector when to be fined. As per section 11, the collector shall make an award under the hand of true land of the land compensation to be allowed for the land is, in his opinion, apportionment of said compensation among all persons known as believed to be interested in the land. Section 12 subsection 1 state that such award shall be filed in collector office and shall be final and exclusive evidence. Section 12 subsection 2 state that the collector shall give immediate notice of his award to the person interested whether present or not when the award is made. Section 12a deal with correction of mistake in award. Mistake may be corrected by the collector at any time, either of his own motion or on the application if of any of the parties. Section 13 deal with the adjournment of inquiry. Collector may, if he think fit, adjourn the inquiry time to time to a day fixed by him. Section 14 deal with power to summon and enforce attendance of witness and production of document. Section 15 deal with matter to be considered or neglected. Section 16 deal with power to take possession. Section 17 deal with special power in case of urgency. Section 18 deal with the reference to court. As per section 18 subsection 2, a person if present when the collector present the award can send application within 6 weeks for date of collector award. In other case, when the person is absent, he can send application within 6 weeks of receipt of notice from collector or within 6 months from the date of collector award. As per section 18 subsection 3, provincial government may refer the matter to court within a period of 6 months from date of announcement of award if it disagrees. Section 19 deal with collector statement to the court. Section 20 deal with the services of notice. Section 21 deal with the restriction on scope of proceedings. As per section 22, every such proceeding shall take place in open court. As per section 22, a provincial government, local authority or company for which the land is acquired may lodge or cross objection to the objection. Such section 23 deal with matter to be considered in determining compensation. As per section 23 subsection 1, court shall takes into consideration the following points in awards of compensation: market value of land at the time of publication of notice. As per section 23 subsection 2, court shall, in addition to market value of land, award a sum of 15% per annum if acquisition is for a public purpose and a sum of 25 per annum if acquisition is for a company. Section 24 deal with matter to be neglected in determining compensation. Section 25 deal with rules for the amount of compensation. As per section 25 subsection 2, if an applicant omit without a sufficient reason, the amount of compensation shall not exceed the amount awarded by the collector in any case. As per section 25 subsection 3, if any applicant omit with a sufficient reason, the amount of compensation shall not be less than or may exceed the amount awarded by the collector. Section 26 deal with the form of award. As per section 26 subsection 1, every award shall be in written signed by the judge and shall specify the amount awarded under class 1 of subsection 1 section 23 and also the amount of, if any, of other class of the same subsection. Section 27 deal with the Section 27 deal with the loss incurred in the proceeding. Cost incurred in the proceeding. Section 27 subsection 1 state that cost incurred in the proceeding and by what person and what portion they are to be paid. As per section 27 subsection 2, if the award of collector is not unhelped, the cost shall be already paid by collector unless the court shall be, if opinion that the claim of applicant was so exigent or neglected and he shall pay of collector cost. Section 28 state that collector may be directed to pay interest or exceed compensation. Part 4 deal with appointment of compensation. Section 29 deal with the particulars of appointment to be specified as per Section 20. Collector shall pay a compound interest on the excess amount of the rate of 8% per annum from date of which he took possession of land to the date of payment of such excess into court. Section 30 deal with the dispute as to be appointment. As per Section 30, any dispute arise may be referred by collector to the decision of court. Part 5 deal with payment. Section 31 deal with payment of compensation or deposit of the same in court. As per Section 31 subsection 2, if there is a dispute as to the title they receive the compensation or as to appointment of it, the collector shall deposit the amount of compensation in court. As per Section 31 subsection 3, the collector may within the sanction of EDO revenue insist of awarding a money compensation in respect of any land, making any of the following agreements: grant of other land in exchange, remission of land revenue on other land held under same title, any other ways as may be equitable, having regard to interests of parties. Section 34 deal with the payment of interest. As per Section 34, when the amount of compensation is not paid or deposit before taking possession of the land, the collector shall pay the amount. Part 6 deal with temporary occupation of land. Section 35 deal with temporary occupation of waste or arable land procedure when different as the compensation exists. As per Section 35 subsection 1, the temporary occupation shall not exceed 3 years. As per Section 35 subsection 2, the collector shall cause a public notice in the locality where the land is located, upon which any officer, either generally or specially authorized by collector, can enter and survey the land. On receipt of plan detailing the land acquired, the collector shall give notice to return to the person interest and pay them compensation, either in gross sum of money or by monthly or either periodically payment, or shall be agreed upon in written between them. Section 35 subsection 3. If there occur difference between the collector and person interest, the matter shall be referred to court for decision as per Section 35 subsection 4. Section 36 deal with power to enter and take possession and compensation on restoration. Section 37 deal with difference as to conduction of land. Part 7 deal with acquisition of land for companies. Section 38 deal with company may be authorized to enter and survey. Section 38 a deal with industrial concern to be deemed company for certain purpose. Section 39 deal with previous statement of previous consent of EDO revenue and acquisition of agreement necessary. Section 40 deal with previous inquiry. Section 41 deal with agreement with an provincial government. As per Section 41, a company may enter into the agreement with an provincial government providing to satisfy the provincial government in following matters. Section 42 deal with the publication of agreement after execution. Section 43 state that Section 39 to 42 not to apply where government bound by agreement to provide land of company. Section 43 a deal with restriction on transfer receipt. As per Section 43 a, any company acquiring land under Section 43 shall not be able to transfer the land except within the sanction of the government. imparted miscellaneous. Section 45 deal with the services of notice. Section 46 deal with the penalty for the obstructing acquisition of land. Punishment for obstructing acquisition of land shall be imprisonment up to 1 month or fine. 1 month or fine up to 50 rupees or both. Section 47 state that magistrate shall enforce the surrender of the land. Section 48 state that completion of acquisition not compulsory, but compensation to be awarded when not completed. Section 48 subsection 1 state that EDO shall be at liberty to withdraw from acquisition of any land if possession is not taken except in the case provided for section 36. Section 48 subsection 2 state that upon withdrawal of acquisition the collector shall pay for the damage incurred. Section 49 deal with the acquisition of part of the house or building. Section 50 deal with the acquisition of land at cost of a local authority or company. Section 51 deal with exemption from stamp duty and fees. As per Section 51, no award or agreement shall be chargeable with the stamp duty and no person shall be liable to pay any fee under this act. Section 52 deal with notice in cause of suit for anything done in pursuance of act. As per Section 52, no suit or other proceeding shall be commenced against any person for anything done in pursuance of this act without giving a month previous notice in writing. Section 53 states that court of civil procedure shall be applied to proceeding before court. Section 54 deal with appeal before court. Section 55 states that provincial government shall have power to make rules consistent with this act. Section 55 subsection 3 states that all rules, alteration and addition shall be published in official gazette and shall thereupon have the force of law.